All right, why don't we get started here? I want to welcome everyone to today's panel, which is titled "What We Know About the CCB So Far." My name is Keith Cooperschmidt. I am the CEO of the Copyright Alliance, and I will be moderating today's discussion. So today, with the help of our terrific panelists, who I'll introduce in a moment, we're going to take an in-depth look at how things are working with the CCB 7 months after its launch by the U.S. Copyright Office. Now, over the past 7 months, there have been many interesting developments and challenges that may help guide prospective CCB claimants as well as respondents, as well as many other people who are interested in the CCB or this new Copyright Small Claims Tribunal. Before we begin the discussion, let me first thank the 15 Volunteer Lawyers for the Arts, or VLAs, organizations across the United States who have joined us as co-sponsors of this event. And I also want to thank all of you, the attendees, for taking the time out of your busy schedule to join us today. Now, if you have any questions for the panelists while you're listening today, please put them in the Q&A section, which is at the bottom of the screen, at the bottom of the Zoom. And then at the end of the panel discussion, I'll ask the panelists to answer as many of them as we have time for. I also think Rachel Kim from my staff is going to try to go on and answer some of them during the course of the event as well. And any questions we don't have time for, though, we will try to answer after the event, and we'll post the answers on the CCB section of our website. So we encourage you after the event to go to our website, because you might find answers to your questions there. So let me kick things off by introducing our esteemed panel. We are excited to have joining us today Maya Burchett, who is one of the 3 attorney advisors for the CCB. As a CCB attorney, Maya is in the trenches every day, reviewing the cases that are filed and working with claimants to get their cases in proper form. I can think of few people with more experience and knowledge about the CCB than Maya, and so we are very, very thrilled and grateful that she is joining us today. Also joining us on today's panel are Tom Madry, who is the Chief Legal Officer and Head of National Content and Education for the American Society of Media Photographers, or ASMP for short, and Terica Carrington, who is the Vice President of Legal Policy and Copyright Counsel here at the Copyright Alliance. Now, both Tom and Terica have played an integral role in getting the CCB enacted through the CASE Act, and have been reviewing and commenting on the CCB rules to make sure they work as efficiently and effectively as possible. So this is actually our second CCB panel discussion. During our first event, which took place in May last year, we discussed many of the CCB basics. I hope you had a chance to watch that panel, but if not, I encourage you to go to the CCB Explain page on our website to watch the recording after this event, because it's got a lot of good information. And in the event you haven't watched that video yet, I'm going to ask Terica to start us off by first giving us a brief overview of some of the CCB basics, just to make sure everyone is on the same page. So Terica, why don't you, if you don't mind, giving us a little overview of the CCB process first?
Sure, I'm happy to do that. So as Keith just mentioned, I'm going to be doing a pretty high-level overview. So if you haven't seen the previous video, please check that out on our website. Before I get started, I'm going to define a few terms that you'll hear us use throughout our presentation today. First, you'll probably hear us refer to the Copyright Claims Board as the CCB from time to time. You'll also hear us refer to the claimant and respondent in a CCB case. The claimant is the individual who is bringing the case, so that's similar to a plaintiff in federal court. And the respondent is the person who the case is brought against, similar to a defendant in federal court. So the CCB is a voluntary alternative to federal court for certain copyright claims, and those claims include copyright infringement, declarations of non-infringement, and DMCA 512F misrepresentation claims. The CCB was officially launched in June of 2022, and I'm going to go through a few highlights about the CCB. One of those is that it's voluntary. And by voluntary, I mean that the claimant has the option to choose to bring their case to federal court still, or they can choose to bring their case to the CCB if it qualifies. And likewise, the respondent has the choice about whether to participate in the proceeding or to opt out. And the reason that the respondent has this choice is for constitutional reasons. The CCB is a simplified and streamlined process, and it was designed this way in order to allow parties to navigate the system without needing the assistance of an attorney. The CCB is located within the United States Copyright Office, which is itself located in DC. But in order to participate, there's actually no travel required. Everything is done completely remotely. So parties who are participating in a case before the CCB are not actually required to travel anywhere. As I mentioned before, attorneys are not necessary, but they can be used if parties wish to have the assistance of an attorney. Alternatively, the CASE Act and the CCB allow for pro bono assistance by law school clinics, which means that law students can actually assist parties throughout this process for no fee required by the party. This is a small claims process, and what that means is that damages are capped, and specifically, there's a $30,000 overall maximum amount of damages that can be awarded in a CCB case. And for statutory damages for copyright infringement, those are limited to $15,000 per work infringed. And finally, there are 3 copyright claims officers who act as judges in the proceedings, and they are the ones who are reviewing all of the evidence presented, reviewing the entire record before them, and deciding the cases. So that, again, that's just a high-level overview, just some things that might be good to know if you haven't already watched the video as you listen to us speak today. But again, if you haven't seen that video, I do encourage you to take some time after our presentation today to check that out.
All right, thank you very much, Terica. So let's start with questions for the panelists. So the title of this event is What We Know About the CCB So Far. So I suppose it makes sense, right? For the first question I should ask you all is, what have you learned about the CCB process over the first 7 months? I'm going to ask Tom to start things off, and then Terica and Maya can chime in after that.
Sure. And first, let me say thank you, Keith and Copyright Alliance for having me out today, and to my fellow panelists. I'm so happy to see Maya here and Terica again for all the great work you all do. You know, ASMP, through the many years leading up to the formation of the CCB, really focused on having the CASE Act, which is where the CCB came from, the genesis of it, be a platform for creators to understand more about copyright. So when I saw this question, what have you learned about the CCB process in the first 7 months? One of the very first things I was thinking are all the conversations I've had in the last few months that indicate we still have a ways to go when it comes to learning basic copyright educational topics, right? You know, the CCB is an alternative, as Terica was saying, but it still functions under the principles of copyright law. And so we've seen this big increase in creators who are seeking to learn more information about copyright, about registration, about what is copyrightable, about all the things that go into a copyright claim. It's only when you have that information and that knowledge, which the CCB's done a really good job of putting together through their resources, and the Copyright Alliance has done a great job putting out information. And I'd also like to think ASMP's done a pretty good job at putting out educational resources. But the first thing I thought of with this question was the fact that this has been the genesis of more people learning more about copyright than anything else I've seen in the last number of years. And that's been really heartening and really exciting.
So I'll go next. So one of the things that I've kind of learned as the process has unfolded, I think in the beginning, when Keith was doing introductions, he talked about, you know, while the CASE Act was going through Congress, we were doing advocacy for the CASE Act and for, you know, the importance of it. Since the CASE Act has passed and the CCB has been up and running, we've been not only educating creators about the process, but also monitoring the cases and kind of keeping an eye on how many cases have been filed and just various statistics. And one of the things that I've noticed is that we're seeing more attorneys being used than I personally expected. It's looking like about 1/3 of claimants are using an attorney when they're bringing claims. And as I mentioned previously, the CCB was designed to be streamlined and simplified such that people could navigate the process without the use of an attorney. So that was definitely something that I didn't necessarily expect. I don't necessarily think it's a bad thing. It's just, something that I've been noticing as we've been watching these cases. I would imagine that because the process is more simplified and streamlined than cases in federal court, there are some attorneys who are willing to take on these cases for a much smaller fee or for a smaller payout than they would charge in federal court. And so that's an interesting development. I think that's kind of coming from the existence of the CCB. With that being said, I do still want to remind everyone who's watching that even though, about a third of claimants are using an attorney, you don't need an attorney to use this process. But I would like to just add that if you do choose to navigate the process by yourself, it is important to educate yourself about kind of like the rules and regulations and the things that you need to know before kind of taking on this process on your own. Again, it is designed in order for people to be able to do that. And so that information is out there, educational materials, not only from the Copyright Alliance, but also from the Copyright Office, from ASMP and others out there as well.
So I'll go next and just again want to thank Copyright Alliance, Keith, Eileen, Terica, the whole staff there for organizing this event and having us. So what have I learned over the first 7 months? Well, here at the CCB, we've learned a ton. We've learned that claimants are really excited to file claims, and we're getting a steady flow of claims. And similar to Terica, I think about the types of claimants that we've seen. As of January 5th, we've had over 170 self-represented parties. So although Terica mentioned there are that 1/3 of people choosing to use an attorney while they go through the process, we also have quite a few people choosing to navigate the process with the help of resources put out by us and resources put out by some of these groups, including the VLAs on this call, including Copyright Alliance. In terms of trends, we're seeing some of the groups of creatives like photographers that really advocated for the CCB take advantage and file claims. We've also seen a lot of claimants use the CCB as an ADR dispute resolution starting point. We've seen a number of cases and claims settle before they start going to some of the CCB processes, going too far down the line, because parties are willing to come to the table. So I think that's really interesting and something that we learned really, really early that I didn't think that we would learn so early in the process here.
All right, Maya, Terica, Tom, that was wonderful. That's great. So next question I have is sort of a spin on the last question, but so before it launched, we all were making guesses and predictions about how the CCB might work in practice. And so, what I'm going to ask you now, are there any aspects of the CCB that kind of surprised you that you just didn't think was going to happen and end up happening? So, anything you've seen so far that you might say is a surprise? So Terica, why don't you go first, and then Tom can jump in after that.
Yeah, definitely. So I think there are lots of things that I could kind of talk about as far as being surprising or being just things that I'm learning as the process unfolds. But one of the things that I thought was particularly surprising is that there's a provision in the CASE Act and a part of the CCB regulations that allows a district court to refer a case to the CCB. So the traditional way that cases reach the CCB is that a claimant would file a case there, bring that claim, serve notice on the other party, and the other party has the option to decide whether to participate or whether or not to opt out. That's a traditional route that a case reaches the CCB, but there is a provision that I think a lot of people may not necessarily be aware of, and that's that district court referral, where a judge can actually refer a case that is before it or before them to the CCB. The caveat is that both parties, the plaintiff and the defendant in the case, have to agree and consent to that happening. And the thing that was surprising was that one of the first active cases before the CCB actually came to the CCB through that district court referral process. I would say that I expected it to be used at some point. I didn't necessarily expect it to be used so early in the process. So that's definitely one of the things that was pretty surprising to me so far.
Yeah, and I think that as you said, there's such a number of things that we didn't know going into the launch of the CCB. I mean, it's essentially the creation of this brand new thing out of thin air, and so I think there's been so much that we've learned, but on the surprising side, I think there's two areas I want to touch on, and one builds on what Terrico was mentioning earlier. I've had the opportunity to speak with a lot of attorneys about the CCB, and they are really curious and really interested in learning about the CCB. I think that's because if you are an attorney who works with creators of any size, your clients are now coming to ask you about, what is this new thing I'm hearing about? What is the CCB? And so I've been surprised at the interest level of attorneys in the CCB, and hearing what Maya and Terrico were saying, I think buttresses that. The other thing I was surprised about, looking at some of the numbers and many of the cases that have been, and many of the claims that have been filed, is the number of international based people who are filing claims. That is just one of those things that I didn't think about extensively beforehand. And so when I saw all the various countries that were represented, and including, let me also say, almost all the states. I mean, it is a wide number of people across the country who have filed claims. Those two things have been very surprising.
All right, that's interesting to know. So, Maya, and I'm going to pick on you now. Because you're in the trenches, as I said before, and you see in these cases come in across your desk every day, and you're talking to claimants and going back and forth with them. And so you're no doubt seeing certain issues pop up again and again and again by claimants. And so my question to you is, and this is a great opportunity to educate people who are claimants or thinking about claimants, being claimants. So what are the most common issues that you're seeing with the claims that are being filed by these claimants before the CCB?
So I just want to say that they're really interesting trenches. They're really fun trenches. We love the trenches over here. So we're seeing different mistakes based on the three different types of claims that we hear. Terrica touched on earlier, the CCB can only hear certain types of copyright claims. And so we're seeing people make certain mistakes based on the type of claim that they're filing. In copyright infringement claims, we're seeing claimants who may not understand some of the copyright infringement basics, or as Tom mentioned earlier, copyright, participants were all still learning these certain copyright basics. For example, to file a claim with the CCB, a claimant needs to be the legal or beneficial owner of a work. We're seeing some claimants who may have filed their registration as individuals. I'm Maya photographer. I took this picture. I registered as under my individual name. However, when they file their CCB claim, they're filing it as their personal business or their LLC or their entity. So Maya Photographs LLC would file the claim, and that causes an inconsistency that we would have to write a non-compliance order about and kind of figure out what's going there. Other times we're seeing people who may be the beneficial owner, people who are due royalties, not doing a good job of explaining how they own the rights that they believe were infringed. So if someone owns the exclusive right in some royalties and they're not, and they plug in that registration information into our CCB form, we're not seeing them in those descriptive fields really tease out how they are connected to a registration. For music claims, we're seeing folks who may be confusing registration in a sound recording and registration in a musical composition. Again, that's getting back to those copyright basics that Tom learned about that we're all still trying to educate people on. Generally speaking, for misrepresentation claims, we're receiving some claims from people who might not understand how technical misrepresentation is of a term it is in copyright law. And just generally damages, we're seeing some people ask for damages and relief for, throwing in that they also hold a trademark. They also think that there's publicity rights involved. And while it's okay to mention that as a part of, maybe mention it as a part of your narrative, you can't ask for relief from the CCB that we can't grant. So we're starting to see people ask for relief for a trademark infringement, or see people ask for relief for injunctive relief, for a respondent to stop doing activities. And, that's a type of relief that the CCB can't necessarily grant.
All right, that's all very, very helpful. And so let me pause here for a second just to say, for those who are listening, who may think, wow, those are good points. I need to understand better about, gee, is this a sound recording or the musical composition, or how do I prove ownership, or issues that basically Maya just raised. I encourage you to go to the Copyright Alliance website. We have a lot of educational material, FAQs, things like that you find, as well as, of course, the Copyright Office website itself has got some fabulous educational materials on there. So I think, as we heard from Terica a little bit earlier, I think it's real important for people not just to file claims, but take a step back, look at what type of claims you can file with the CCB and what type of information you will need to file those claims to make it easier for that claim to kind of flow rather easily through the initial system, at least. So with that, let me turn to Tom and Terica again. Now you both represent and work a lot with creators. Tom, in your case, mostly photographers. Terica, in your case, the Copyright Alliance, we represent just about all types of creators. And no doubt you heard a lot of feedback from them about the CCB, different aspects of the CCB. And looking through the questions that are coming in so far, I see a couple of these questions look familiar, like the typical questions we get from creators I know here at the Copyright Alliance. So let me ask both you, Tom and Terica, what do you think is the biggest obstacle to successfully bringing a claim with the CCB? Like, what have you heard from your creators is kind of the most difficult thing, or things, it could be more than one, for them to bring a claim before the CCB? Tom, why don't you start off, and then Terica, you can jump in after.
Yeah, I think that, as I mentioned earlier, the CCB came out of nowhere into this new entity, right? And so there are going to be areas that are going to work just as expected, and others that are going to prove tricky. I think the number one thing we hear from our members and from creators when it comes to obstacles is this idea of service, right? Service means something very specific under the law. And there are certain ways that you have to perform service so that the other party, the respondent, is on notice in the proper way. Now, the trick here is that the requirements of process of service are state specific, right? And so you go to file a claim with the CCB, and there are steps in the claim where you have to process service upon the respondent. This is tricky. It's tricky for attorneys who are doing it as part of their job as litigators. It's particularly tricky for creators who may not have ever been involved in any kind of judicial proceeding or any kind of mediation or anything like this. Now, the CCB has done a good job of identifying, where some of these problem areas lie. But when I talk to members, what we're seeing is a lot of confusion and a lot of not complying with the specific rules of the various state where the respondents are. Now, this gets into another area of, well, let's say you're a photographer, like some members that we have who I've spoken with about this, and there are multiple people who might have infringed the work, or multiple respondents in a matter that are tied together in one way or another, but those people may be in different states, right? And so now we have questions about how are we going to serve the respondents? I think this is an area that all the parties on this call are both aware of and trying to find unique and creative ways to help creators who are running into some of these issues. But I would say the number one obstacle that I've heard more than any other has to do with this idea of service and the proper way to inform the other party that that they've made a claim. I'll stop there for now.
Yeah, so just to kind of echo what Tom just said, likewise, I've certainly heard many people talking about service as an obstacle that they faced. I think Tom brings up a really good point about just how there's sort of this learning curve and this gap that creators who are coming before the CCB kind of have to fill in. And along those same lines, one of the other obstacles that I've noticed, and this is what I wanted to talk about, and it's been touched on a little bit as well by both Maya and Tom, but it's just this basic lack of knowledge and lack of understanding of the actual copyright law and how to articulate, for example, how to actually articulate a specific claim that a person has. What I find interesting about both this topic and the service issue that Tom just talked about is, these are both examples of gaps things that an attorney would typically be doing in federal court. And because this process is one that in a lot of instances, individuals are, attempting to navigate on their own, there is definitely a learning curve. There's some things that they have to learn that they traditionally wouldn't have to really know about. I mean, traditionally they're showing up, meeting with their attorney, just telling the attorney the facts about what happened, and the attorney is kind of filling in the rest of these gaps. For a lot of creators, this is their first real opportunity to have their claims heard. And so they're very eager to bring those claims. And although the process is designed to make it easy for them to navigate the system without an attorney, there's definitely a certain level of responsibility on the claimant to make sure that they understand the claims that they're bringing and to make sure that they understand how to properly articulate those claims. I think people generally have a basic understanding of the fact that they have rights, that there are certain things that are not allowed as far as what other people can do with their works, and they have an idea about that, but it's difficult in some instances for them to necessarily articulate the nuances of that claim and do so in a legally sufficient way. So again, that's one of the other, in addition to service, I think that's one of the other biggest obstacles that I'm seeing. And again, I just think it has to do with, I think as this process, again, the CCB is still very new. It's a very young process. I think we're all still learning a lot about it. But I think over time, as people get more experience with it, as we, do our part to continue educating users of the system, we will see those issues kind of improve. But I do think because it's only been about 7 months, and this is an entirely new process with people who, in many cases, have no prior experience with navigating the legal system on their own in any way, it's definitely going to be a learning curve that we're going to continue to see, some stumbles with, but I think over time it'll certainly improve.
Yeah, I'll jump back in just real quickly on that and say I think that the things that I raised and Terica raised are both examples, as Terica noted, of things that an attorney might be doing for a client in other contexts. And I think that introduces one of the main issues is that the CCB and its amazing staff have been so responsive on so many elements, but they can't give legal advice, right? And so you run into these areas that I'm talking about and Terica's talking about. And unfortunately, the CCB isn't able to have the remedy that you might be seeking. And so I think it's just important to keep in mind the limitations of what the CCB can help with, and then what you might have to do some additional research on your side, so that, as Maya was saying earlier, you're making a claim that's compliant and your claim moves through the system appropriately. It also helps all of the organizations like the ones on this call who are creating educational resources to hear from people who have brought claims and to hear the issues that they're having, so that we can be responsive and help fill in some of those gaps. And I'll just add one more thing in here. We mentioned it right at the very top, but there are provisions in the CCB regulations that allow for both pro bono and student representation. This is something that ASMP has been particularly focused on. And it's an area where I think the VLAs who are on this call may have a large role to play here, because a lot of the VLAs that I'm here in Texas, Texas Accountants and Lawyers for the Arts, where I'm privileged to sit on the board, and we are getting these type of questions that come in about these particular issues to our legal lines and other forums. And I think the VLAs may have an important role to play to fill the gap that Terica and I are talking about on some of these specific issues.
And just really quickly, just to piggyback off what Tom was just saying, there is a database on the Copyright Office's or the CCB's website that it's going to list out different legal clinics and different pro bono services that will provide assistance with the CCB. I believe there probably aren't, I remember the last time I checked, there weren't many entries so far, but again, because this process is new, I think clinics across the country and different organizations are kind of gearing up, learning about the process, making sure that they have an understanding and they have the resources available in order to properly assist parties who want to navigate the systems. But I do encourage you to check out that database. And, you know, if for instance, maybe you don't want to hire an attorney, but you're not necessarily fully comfortable doing it on your own, there are resources out there that can kind of help fill in that gap as well.
I'm going to hop in for a quick second just to plug, because I know we have a number of VLAs on this call. VLAs, if you have questions about the CCB, we're more than happy to offer you a webinar to talk through some of the issues, to talk through the CCB process. If you go ahead and email us at asktheboard@ccb.gov, someone will be in touch. We're constantly looking to add VLAs and other organizations to our resources list.
All right, so we've been talking a lot about questions that people have, and I'm just watching the Q&A fill up here, and so we're going to want to get to those, which we're going to get to in a minute. But I have one more question for this one's for Maya, actually, before we get to the Q&A that I'm seeing here. So Maya, I know you said earlier that you'd love being in the trenches, and you love the trenches, but maybe we can make you love the trenches a little bit more, right? And make your job a little bit easier. And so I'm giving you the opportunity here. You have the floor. If there are one or two things that you could ask claimants out there, maybe there's potential prospective claimants out there listening in, and you could ask them to do certain things or to make the claim review process more streamlined and easier for everyone, not only you, but for them, of course, as well. What would those be? What would be those, 1, 2, or 3, whatever number you have, of things that you would ask these claimants to watch out for and do when they file their claims?
So that's a great question. And it really dovetails well to what we were discussing earlier. We really want people to tell their story, and it helps in the later stages of a claim if claimants think through every element of their claim and give us a well-detailed factual statement of their side of the story. Terica was mentioned that we want people to ask themselves certain questions. If you ask yourself certain questions in the beginning of the process, the answers to those will often elicit details that have legal significance. So if you go to, the first thing I would ask people to do is to review our resources, review the materials that we have. We have a handbook that asks some of these questions that will help elicit factual answers that will help your claim go through. So what does that mean? It means that thinking through some of these questions that we pose in our handbook, thinking thoroughly about some of these questions that we ask in the claim form will really set your claim up for success, not only through the compliance review process, but later on. So for example, thinking through, what is my registration number? What is the title of my work? What type of work is it? Do I need to show that I'm a legal or beneficial owner if my name doesn't match that of the registration? How did the respondent see or have access to my work? Am I showing or telling my story through screenshots? As we've mentioned earlier, the CCB is staffed with experts, but it really helps us when people detail their story fully, tell all of the facts that they have, because that really helps us nail down the copyright issues that are involved in the claim, and it helps narrow the issues down for the respondent so that they know what they're responding to. But the more so the first thing I would say is to review the materials that we have and be as detailed as possible. So that leads into the second thing, which is to note that the ECCB fields do not have a character limit. So please be as detailed as possible. You're not asking people to necessarily become lawyers, but you know the facts of your side of the case better than anyone else. So the telling your story in those boxes, describe your infringement. It's a really basic question, but what we're asking for there is for you to tell your side of the claim so that we can kind of suss out what's going there. And the more detail you use in doing that, the better. The third thing I would ask people to do is to label their supplementary documents. And this seems like a very small thing, but the last step in your claim form on ECCB is you have the ability to upload supplementary documents. If I'm a photographer, I can upload a screenshot of the allegedly infringing work on a website or on Instagram or on some of these other online service providers. So upload those supplementary documents, but label those supplementary documents. If you're trying to show that, if I'm trying to show that Terica's photograph is similar, is Terica's using my photograph on her blog site, I'm going to want to upload my photograph, a supplementary document potentially of my photograph, and a screenshot of the photograph on Terica's website, and labeling those so that we can see. We have been seeing a ton of hyperlinks, which are a little bit trickier because, hyperlinks, especially if you're sending takedown notices and other things, or if, someone knows that you're going to file a claim, hyperlinks break and come down. So if you have screenshots, the more the better. So those are kind of my three things. Review the materials. There's a ton of materials out there on, like I said, ccb.gov. Our handbook is up there. All of the lovely people on this call all have their own resources. So one, review the resources. Two, be as detailed as possible. And like I said, you want to ask yourself some of these questions that all of our resources and materials lay out, because we're asking those questions because they elicit legally important details. The third thing, again, it's simple, it's quick, it's labeling your supplementary documents.
Thanks, Mike. That was tremendous. I have to believe that that's going to be very, very helpful for all the claimants that are out there. So let's turn now to some of the questions that we're getting come in, and there's so many. I'm going to group a couple of them together because there's a few at least that are very similar, kind of touch on the same topic. And the first one I'm going to ask has to do with the types of cases that are being filed. For instance, we have one attendee who's asking what kind of volume cases is the CCB dealing with? Is that number going up? Is it staying steady throughout? Do you feel the CCB is still under the radar, and as time goes on, maybe the volume of cases will go up? What type of resources do you have to handle this caseload, things like that. Another question related to, are there trends about what disciplines are more likely to use it? For instance, is it more visual arts cases than music, things like that? So I'll throw that out there. There's all other questions that are asking about the types of cases that are being filed, but maybe we can talk about that a little bit, the type of cases that are being filed, how many, how they're being handled, things like that. And it probably makes sense to either start with either Maya or Terica on this one, I think.
So I can say that we've had a steady number of cases. We had, I want to say 280-ish, give or take a few case claims in December, by the end of this, from June to December. So we're seeing a steady flow of cases. Presently, we're fully staffed up. There are 3 copyright claims attorneys, of which I am one. As Terica mentioned, there are 3 copyright claims officers. And so we at the office are not really worried about the caseload as of yet. The type of claims we're seeing a ton of infringement claims. The majority of the claims we receive are those copyright infringement claims. We've received a few non-infringement claims and some misrepresentation claims, but a bulk of claims are the copyright infringement claims, and a bulk of those copyright infringement claims have to deal with visual arts works. Now, we have received music claims, we have received audiovisual claims, motion picture claims. We have received, even a computer code, situation. But the majority of our claims right now are visual arts claims. So I'll kick it to Terica if she has anything else to add there.
So I think you covered everything as I would expect you to, Maya. Just a couple of updates. As you know, we're keeping track. We do keep track regularly of the number of cases filed, and we try to do a summary at the end of each month as well. So yesterday was actually the end of January. So as of yesterday, there have been 324 cases filed. So I think, Maya, you said at the end of 2022, there were like about 280. So that's another 40 or so cases filed throughout the first month of this year. And then also, as Maya mentioned, the vast majority of the cases involve visual works. I think photographs, graphics, et cetera, are kind of the number one that we're seeing as far as subject matter of the cases. And then in second place, I think we're seeing motion pictures and audiovisual works. And then the third most popular is literary works.
All right. So another group of questions we've gotten has to do with, either foreign claimants suing a respondent, or the inverse, where you have someone who knows there's an infringement going on abroad in some other country, and they perhaps want to bring in action there. So can you talk a little bit about, first of all, I think one of the questions was the percentage of foreign claimants from other countries who are bringing actions within in the CCB. And then also, I know this is more of a legal question, the second part, which is, can like a US resident citizen bring a case against, if they know someone's infringing their work in a different country, can they go after that person in the CCB?
That's a great question. So you're correct. We've received claims from a number of international claimants, excuse me. And that is perfectly acceptable and fine. However, you talked about the flip side. So if I am a US creator or a US claimant, you cannot use the CCB to go after a foreign entity or individual. And that's nothing that we've done here at the office. That's in the statute. So if I know a number of people are upset about that, and you can take that to Congress. But because the CCB is voluntary, because we have these constitutional constraints, we cannot handle foreign respondents, for one of the reasons being what Thomas mentioned earlier, is that service issue is tricky, and adding a foreign element to that is just unwieldy. So yes, you can be an international claimant. No, you cannot be an international respondent.
And just to add to that, I know that Tom mentioned early on this being one of the things that was surprising to him. And likewise, I thought this was surprising too. We're actually seeing more than 10% of the cases filed have actually been filed by foreign respondents. So I do think that, foreign residents. I do think that that's not necessarily something that I expected to see either. I did just want to add one other caveat to what Maya mentioned, is that, a US resident cannot bring a case against a foreign respondent. However, if a foreign resident does bring a claim against you as a US resident, you can bring a counterclaim against them. So there is that opportunity to, if someone who, resides in a foreign country brings a claim and you have a claim that is viable before the CCB that you want to bring against them as a counterclaim that's related to the claim that they brought, you can do that. So that is the exception. But again, as Maya mentioned, the general rule is that a US resident cannot bring a claim against a foreign resident.
All right, Tom, I have one I think that is right up your alley here. So we'll see.
Right.
Not looking for any legal advice here, to be clear, but we have one question that says, before bringing a case at the CCB, should the person send a cease and desist letter prior to filing that claim? Does that make some sense? And then they go into detail I won't repeat here because they have specific instances that they're talking about. So, but as a general matter, does it make sense to send a cease and desist letter first to the party?
Yeah, so I'll it is a question that I think is often pretty fact specific, but let me kind of give some guidelines that I often talk to with our members and with creators, and it's my view that resolution should always be the goal, right? And so you have to evaluate what type of claim it is, what type of alleged infringement it is, where you found the work, how widespread you might believe it is, but also understand you might only know the tip of the iceberg when it comes to infringements. You know, if you're a photographer who's had their work out for any period of time, there are vastly more people who've infringed your work than you likely will ever know about, right? Now, when it comes to should you file or should you send a cease and desist, or should you simply file a claim, you know, it's my view that you kind of work in an escalating fashion in most cases, right? And so if you have some ability to interact with the infringer, maybe that is a route that you take. I give you a great example. I was talking with a member the other day who there was someone in their local community who utilized their work in a local publication, and that's the type of thing that they were able to get a satisfactory resolution, you know, which included monetary payments and you know, ensuring that the work was licensed appropriately and all that, without having to go any further than simply picking up the phone and sending an email. But there are also cases where you can immediately identify that the specifics of the matter are such that either a letter from you might not be effective, what you might know the person or not know the person, or you might determine that this scope of whatever you have found the infringement to be is larger than you feel comfortable for whatever reason engaging in. Then you have another choice, right? Then your choice is, well, do I look at the CCB and a pro se kind of representation? Do I look at speaking to an attorney? You know, one point that was brought up earlier, and now I'll speak kind of specifically for photographers, is, you know, we've been, and this was brought up by a member and a claimant talking about, you know, attorneys should likely be adjusting and modifying downward their fees for representation in front of the CCB. And I think that's something that we would be encouraging because of the nature of this. All those things go into the calculus of, do I send a letter or not, or do I go right to the CCB or not, which I know is a whole lot of words to not answer your question, Keith. I would say this, think of it as an escalating curve. And if you think with the goal always being resolution, right? That I will end this by saying there's one great provision of the CCB that allows for micro claims under $5,000 to have an expedited process. If you are in a situation, as many photographers I've talked to are in, where you might have found an infringement and you know it's limited in a certain scope, and it might fall into this, the CCB may be an earlier option for you simply because there's a pathway to resolution, which is always what our goal is. I try to keep everyone out of court as much as we can.
All right, thanks, Tom. So another question we've got is about injunctive relief. And we get questions about the CCB, can they issue injunctive relief? And then we had someone else ask a question about, well, they know the CCB can't issue injunctive relief, but how is this other process working? Is it leading towards settlements? Are there settlements going on as well in these cases? And so just sort of a general question about injunctive relief, getting the other person to stop what they're doing, and whether some of these cases, once they're filed, have led to any settlements. I don't know if we probably don't have any hard and fast evidence there, but does anyone want to jump in and talk a little bit about injunctive relief and what we know or we think we know about potential settlements?
Yeah, I can talk about injunctive relief. So as I think the person who, or one of the people who asked this question pointed out, there is no formal process for injunctive relief through the CCB. So basically what I'm saying is the CCB officers cannot issue an injunction as part of their determination in a case. With that being said, there is a feature of the CCB that kind of functions in practice like an injunction. And that's basically if the person who is being accused of doing a certain act, so let's say someone is being accused of infringing someone else's work, if that person agrees to cease that infringing activity, the CCB officers can take that into consideration. So they can actually take into account whether or not that person has agreed to cease that infringing activity when they are determining the amount of damages to award in the event that the accused actually loses their case. So what that basically means is, let's say your decision to affirmatively agree to cease that activity could be used and taken into account by the CCB officers, and they might award a lesser amount of damages, just taking into account that, you know, you've agreed to stop, and that could have a lesser impact long-term on the copyright owner. Alternatively, they could look at your decision not to cease that activity and take that into consideration and perhaps increase the amount of damages that they're going to award, just to account for the fact that you may continue, you know, doing that activity. So again, it's not a formal injunction, meaning that basically the CCB officers cannot unilaterally on their own issue this, but if the party who would be the person who would need to stop the activity, if they agree to stop that activity, the CCB officers can actually include that in their final determination, and that would become part of basically the final decision. And so it would operate very similarly to what an injunction would do.
I can hop in on the second part of Keith's question about settlement. So we do know that certain claims have settled, and the great thing about settlement is that, you know, it's a really customizable option that's available to you and another party. You know, Thomas kind of mentioned his dispute curve, which I'm gonna, you know, steal that analogy later. But, you know, one of the interesting things is that, you know, your settlement can include terms that the claimant will dismiss your claim without prejudice. So meaning that the claimant can't bring that claim again if you decide to stop that activity. The CCB will ask participants to consider settlement at certain points during a proceeding. So we will ask claimants to consider settlement after a claim has been filed, it's been served, and there's a response in that first kind of conference that the CCB holds before discovery. You will be asked about, you know, have you guys considered settling? Again, after the discovery phase in a proceeding, we will again, the copyright claims officer will again ask, hey, okay, now that you guys have this discovery, you have all of these documents, all of this information, does that change your views on settlement at all? So there are different points where participants will be asked about settlement, and if necessary, the CCB can hold a settlement conference to kind of help these parties mediate towards an agreement.
All right, thanks, Maya. So we've got about 4 minutes left here, and we got a lot of good questions. So I do want to encourage the questions to keep on coming in, because what we are going to do is we're going to answer any we cannot answer. We're going to answer on our website later. So just keep that in mind, because we're not going to be able to get to all of them. I'm going to ask for kind of short answers. I'll try to answer 3 more questions here real quick, each in a minute, sort of like a speed dating, but a speed CCB, we'll call it. I guess opt-out. We're getting a lot of questions about opt-out, like asking, well, wait a minute, if somebody can opt out, why wouldn't everyone opt out? Why is it worth the trouble? All that type of thing. So I'm going to throw that to, I guess, Terica, if she'll answer, and then if anyone else wants to join in real quick.
Yes, okay, I got 1 minute. All right, so I'll just highlight a few things. I think the biggest reason why people wouldn't opt out is the limitations on liability. Again, this is a small claims process, so the damages that could be awarded, statutory damages for infringement are up to $15,000 as compared to up to $150,000 in federal court. So I think that's one of the biggest reasons why a person might look at this and choose to participate, particularly if they realize that the claim brought against them has merit. You may not want to take the risk of going to federal court and end up paying significantly more than you would have if you had gone to the CCB. I think the expertise of the CCB officers is an important thing to take into consideration. Federal judges may not have very much experience with copyright. If you feel that you have a strong case and a strong, defenses, you may want to, rather than taking the risk in federal court, rely on the expertise of those CCB officers. There's also the convenience of not having to go anywhere. Everything is fully remote, as I've mentioned before. And then another thing that I think sometimes people don't think about or take into consideration, and this is going to come into play more so if the respondent is a company that has insurance. There are certain insurance considerations in certain times when a company has a lawsuit brought against them, they are required to run that by their insurance if they want the insurance to potentially pay out if they're found liable. And so similarly with the CCB case, some of these companies that have insurance are going to need to run that by their insurance provider. And that, the people there may actually take into consideration, okay, there's significantly limited risk at the CCB as compared to if this case ends up in federal court. And so in some instances, you may see companies choosing to participate in the CCB process. Again, just going back to that risk kind of comparison between CCB and federal court.
And real quickly on that, if you're an attorney, and a lot of attorneys work with mid-sized, small, medium, large businesses, and they get a CCB notice, this caps your upside risk. And I think that attorneys need to really be understanding of how beneficial it can be to not opt out here, especially if the claim has merit. This is a venue that can make sense for a lot of companies. Doesn't make sense for every claimant or every respondent, but for a lot it will.
Okay, we also got a question about defenses that a respondent can bring before the CCB. I don't know if anyone wants to just talk very, very broadly about that. Obviously, it's going to depend on each specific case, but anyone want to just in about 30 seconds address that? Okay, I can address it.
Go ahead.
I think you can go ahead.
I'm gonna jump in, use moderator's prerogative and answer the last two questions real quick, which is people asked about defenses that respondent can bring before the CCB. I mean, the short answer is any defenses that can be brought in federal court can also be brought here at the CCB. So people are probably want to know about fair use. Absolutely, fair use defense can be brought up at the CCB level, as well as, like I said, any other defense that could be raised in the federal court. The other question we got a lot of questions about, which are this is an easy one to answer, which is what trends are we seeing in terms of the final decisions by the CCB? And that's easy because there have been no final decisions yet. It takes a while to get through this process before the claimant, the claim is filed and then it's served, and then it goes to the, becomes an active case. And that beginning part takes at least like 6 months or so, 5 months. So, and here we are in the 7th month. So we haven't really seen any final decisions yet, but I'm confident we will see quite a few in 2023. So this is something you're going to want to pay attention to and focus on, I think, during the course of this year. And no doubt, we will definitely be back later in the year to talk about, how things are going so far after maybe a year or so. So keep an eye out for another webinar that we will do. I want to thank our panelists. We have covered a lot of ground here. They have done a marvelous, marvelous job. I want to thank our attendees. Some really great questions. We just didn't get a chance to answer them all, but we will do that, and we'll post the answers up on our website. So please check back on our website in a week or two, however long it takes us to put them up there. We'll try to notify you when we do answer them. And if you still have some unanswered questions, you can go to the Copyright Alliance, go to our website under the CCB Explained page. We have lots of videos and FAQs and other educational material about the CCB on our website. You can also call our CCB hotline at 888-5403-CCB, where you can get more information. Once again, that's 888-5403-CCB. And we might even throw in some Ginsu knives also. And of course, the CCB itself has some great resources, which is, at the Copyright Office, and there at ccb.gov, you'll want to check out. So talking very fast so we get this in under an hour. Thank you very much for attending. Hopefully you all found this to be very valuable and helpful. And hopefully we'll see you back at our next webinar on the CCB or anything else that we might do relating to copyright. Thanks, everyone. And thanks again to our panelists.